chat and I'll direct the comments for you. Good morning and welcome everyone to our CEO hosted training session today. Today we'll be discussing the use of evidence at the CCMA and the Bargaining Council. This is presented by the CEO Training Division, and we are lucky enough to have our Provincial Manager from the Western Cape, Stephen Kirsten, today to present, as well as our Senior Dispute Resolution Official, Arlene Jacobs. Welcome, guys. You can move on to the next slide there. All right. Just as a point of departure, my name is Carl Ranger. I'm the head of training at CEO. My details are on the screen there. For any queries or questions, or maybe you have some comments, you please feel free to pop me an email, as well as our two guest speakers today. Their details are also on the screen. It will be available after the presentation on the last slide as well. And without further ado, let's get going. All right, just one or two housekeeping matters before we begin. We are streaming on multiple platforms today. Hopefully the platforms are up and running. We're streaming on LinkedIn, on YouTube, and on Facebook. You can tune in from your smartphone or on your PC. The video recording and the slides, this is a question we get a lot of the time. Will they be made available afterwards? Yes, they will be. You can find them on our CEO page on YouTube and on Facebook and on LinkedIn. The video and the recording, or the video recording and the slides, will be made available. So if you miss it or you have to leave early, it will be available afterwards for you to interact with and to watch. Please feel free to interact with us. We are streaming from a different platform, StreamYard, today onto the various platforms that you guys will be watching through. We can interact through the comment section. So if you do have any questions or queries or anything you want to add, please feel free to interact with us. Don't be shy to participate. We will address your questions as we go. So we won't leave it till the end. If you have a question on a certain topic, I'd love to address it with the relevant presenter at the time. And I hope you guys enjoy it. Today is going to be a good session. We're delving a bit deep into evidence, and I'm looking forward to hearing what our presenters have to say today. All right, before I hand over, I just want to touch on the purpose of today's training. As with all our other training sessions, this is the fourth training session that we have been presenting live. So our purpose for today is to obviously empower and equip our members and prospective members. That is always the first order of business. We offer a platform of support here from the CEO Training Department. My goal for you guys is not just to inform you, but also to transform your perspective and experience through these interactive sessions. We hope to foster growth and development within CEO, and obviously to our prospective members, and also to leave you guys feeling informed and knowledgeable on the topic at hand. On today's topic in specific, we'll be dealing with the introduction of law of evidence. This is quite a interesting topic. We can be spending a whole semester on it alone. There are numerous works and textbooks and literature reviews and all sorts of things regarding law of evidence. But we want to break it down into understanding the different types of evidence for you guys, to overview the admissibility, weight, and effectiveness of it. We want you to understand how to introduce it and corroborate it, all within the perspective of the CCMA and the Bargaining Council. So we will be breaking it down in a more basic way, especially aimed at our audience. Maybe some of you have LLB degrees and you're here for the more technical part. I'm sure our presenters will touch on that, but our obviously, given the time constraints, it is aimed at more of a basic overview of the law of evidence. And then ultimately, this should leave our members, prospective members, and employers with an understanding of what is expected of them at the CCMA and the Bargaining Council. All right, so before I hand over, we're just going to quickly look at the agenda. So this is still part of our training series, piecing together the processes. We're going to be handing over to Arlene Jacobs to touch on the law of evidence and the types of evidence. And then we'll transition to Mr. Stephen Kirsten for the admissibility, weight, and effectiveness of evidence, as well as introducing and corroborating it. And that'll pretty much be our discussion today with our overview. So without further ado, we can move on. All right, Arlene, I'm going to hand over to you to take us through the law of evidence. Thank you so much for being here. I know it's your first time presenting on our platform today, so welcome, and please take us away.
Thank you very much, Cole. Hello, everyone. I am Arlene Jacobs. I'm from the Bloemfontein office in CEO. Thank you very much for having me today. So I'm basically just going to run through the slides. If there's any questions, you're more than welcome to pop them into the comments. Okay, so when we look at the context of the law of evidence and where it comes from, most cases refer to the CCMA and bargaining councils, I believe, come or stem from dismissals for misconduct. This was after a disciplinary hearing was held or a disciplinary inquiry. So the arbitration proceedings is basically a replay of the disciplinary hearing, giving the applicant or the employee a second chance to overrule maybe the finding of guilt for the specific misconduct. So the focus in most arbitrations is thus to see whether there was sufficient evidence before the chairperson to give or to make a finding of guilt for the misconduct. So that's why we say that the rules of evidence is central in assessing the evidence, is we have to present our case in a way that the commissioner can find on a balance of probabilities that the dismissal was fair. So I believe that knowing the rules of evidence in any arbitration or even in a disciplinary hearing cannot be done, or the case cannot be done without knowing the rules. Okay, so the presiding commissioner can only make decisions based on the evidence that has been presented. So if you don't know what to present and how to present it, you cannot put your case before a commissioner properly. So therefore, it's critical for employers to understand the rules of evidence and to present the evidence to the best of their ability during disciplinary hearings, but especially in arbitrations. Okay, so I think a very important part, and I think something that is very misunderstood, is that evidence is not an argument. It is a form of proof that is used to support an argument. So we'll look at the different types that can be used to support your argument, but without evidence to support your case, the prospects of success are slim. So what is the law of evidence? So the law of evidence, also known as the rules of evidence, are the rules and legal principles that govern the proof of facts in any legal proceedings. These rules determine what evidence must or must not be considered by the presiding officer or commissioner in reaching his or her decision. And I think that's quite a mouthful, but I think when we break it down in the types of evidence, it would become more clear what that means. So what it comes down to is a balance of probabilities. Whose version and evidence is more probable? What is the weight of your evidence that you put before the commission? What can be considered? What is relevant? What is credible? Okay, thank you. You can go on to the next slide. Thank you. So when we look at the basic rules of evidence, there's different types of evidence that can be presented, and I'll go through the different types a bit later. I know Stephen is also going to touch on the admissibility of evidence, but just to give you some information or evidence is not admissible and cannot be used. Now, you can discuss this for hours on what is admissible and what not, but just to give you a very basic example, is evidence that is illegally obtained is not admissible. Hearsay evidence would in most cases also not be admissible. However, it can be admitted by a presiding commissioner, depending on how much weight you attach to it. So I believe Stephen will discuss that for you and make admissibility clear, but it's just certain evidence that you present will be admissible, certain will not, but the presiding commissioner would have the ultimate decision whether it is admissible or not. Okay, then the second rule, or another basic rule of evidence, is the relevance to it. So during arbitrations, there are often disputes about what is relevant and what's not. And when we look at the relevance, we will generally look or ask the question of whether this information will assist the commissioner in making a finding on a balance of probabilities whether the dismissal was fair. So, but if parties cannot agree on this, a commissioner would have to decide whether it's relevant. So in most cases, and I think this is where suits comes in a lot, objection commissioner, objection judge, Your Honor, relevance. And this is disputed in a lot of cases. What is relevant? And I think the most important thing about relevance is, let's say an applicant is dismissed for absenteeism. Only evidence presented on that charge, what the applicant was dismissed for, would be deemed relevant. So if you deliver evidence regarding gross negligence or dishonesty, it wouldn't assist the Commissioner in finding whether the dismissal for absenteeism was fair.
Sorry, Arlene, before you move on to the next point, I just want to interact with the audience a bit, Jack, quick. We have two comments that have come through. The first one was just regarding the copy of the recording and slides. I see it has been answered by our national manager. Thank you so much for that, Chandra. Just to reiterate, the recording or the recording will be available on our platform, which will include the slides. However, we won't be sending the slides out separately. So I hope that answers your question. And then the next question, that came through was, would the rules of evidence referred to here be the statutory and common law rules applied in civil litigation? So yes, the rules of evidence apply to criminal and civil separately. And then obviously labor would fall under the civil sphere. So yes, the rules of evidence are broken down specifically for the CCMA and the Bargaining Council, but it does fall under the civil litigation law of evidence. So just to answer that question. Thanks, Arlene. You can continue.
Thank you, Colin. If I can just add to that, how I'm addressing it, I'm specifically addressing it in my experience, how commissioners will approach the law of evidence. So I think that's also important, even though it is for all spheres. I think commissioners also make up their mind on how they will deem or deal with the law of evidence. So if I'm only focusing on that, that's the reason why. Okay. So as I said, with regards to relevance, if the parties cannot agree whether certain evidence that is presented is relevant or not, the presiding commissioner will then have to decide whether such evidence will be deemed relevant and what weight to attach to it. Okay. So, then the third thing we can look at is the credibility. So, a presiding officer must consider the inherent probabilities of the version put before him and whether it's consistent and corroborated by other evidence. So, let's look at the credibility of any witness. If I call a witness to the stand and in evidence in chief I ask questions and the witness says no, the employee arrived at work at 7:30. And then under cross-examination, the witness changes his version and says, no, the employee only arrived at work at 8 o'clock. Then the credibility of the witness is at play. The commissioner might find that the evidence or the version put before him is not credible. But if we take the same witness and that witness testifies under evidence in chief that the employee arrived at work at 7:30, remains steadfast under cross-examination, and it's corroborated by an attendance register that says he did arrive at work at 7:30, then that version will be deemed as credible. I hope that makes sense in my example. Okay, then if I can move over to the best evidence rule. So this is what emerges from all the evidence you've now put before the commissioner on the day of arbitration. So, Lady Justice with her little scale, if we look at the collective weight of all the evidence we've put before the commissioner on the day, we look at the scales of justice. So this enables the presiding commissioner to decide which side of the scale carries the most weight. Sorry, let me just take a slip. Thank you. So, as I stated before, it makes it very clear that employers should use or present their evidence to prove their case on a balance of probabilities to make their scale heavier than the to make their scale heavier than the side of the employee. Okay, thank you. You can move on to the next slide. Okay, so is there any questions on that, Cole? Can I move to the types of evidence?
No, just a comment here that we got. We're having a great discussion, it seems. So thank you so much for that comment. We really appreciate the feedback from the audience. And Arlene, if there is a question, I will politely interrupt you so we can deal with it as we go. Thank you.
Thank you. Okay, so before I give over to Stephen, I want to go through the different types of evidence. So if you go into each of these, this can take you hours, so I won't keep you busy for that long, but I do want to touch on them as I do think it's important and gives some clarity. I apologize, thank you. Someone is just bringing me water, thank you. I believe that if we touch on these, it gives clarity for an employer or an HR, whoever, just to present their case in a better way. So when we look at oral evidence, which is, I think most of these are self-explanatory, but I think your oral evidence is your most important type of evidence during a disciplinary hearing or an arbitration. Okay, the witnesses that you call should not only corroborate each other, but they should also corroborate all the other evidence that you've put before the commissioner on the day. All witnesses need to be well prepared, and sometimes a disciplinary hearing can take place in August, and now your arbitration is set down for December. Sorry. So now you have 4 or 5 months that have passed between these two dates, and your witnesses can't remember dates, they can't remember exactly what happened. So then it's important so that you can prepare your witnesses so that your oral evidence that you present to a commissioner is corroborated with everything else that you are putting before him. Okay. Your next one is your documentary evidence. The list can go on and on this one. This is basically any documents, black on white, that you can put to support your case. This can include your notice of disciplinary hearing, your minutes, pay slips, contract of employment, only to name a few. And I think it's quite self-explanatory after that, but it's important to prove that the documents that you are putting before the commissioner is authentic and trustworthy. Okay, then the next one is one that I haven't used so often, but it can be used in your arbitration, which is objects. I did a case where we had to discuss the importance of a mask in the workplace, especially after COVID. And an employee was told to wear a specific type of mask. And he refused to wear that mask and wore a different material type of mask. So we took both masks to the arbitration to show the commissioner the difference between the two. This also made it very easy for my witnesses to show the commissioner the importance of the instruction between the two masks. Sorry, I'm just going to mute myself so I can just take a sip of water.
While you take a sip there, Arlene, I just want to jump in to add. So usually you always see in the dramatic television shows where there's a criminal trial and at court and they said, this is the murder weapon, and they brought it in to show the jury, usually with the American television. But in the CCMA and the bargaining council context, it doesn't happen as often where you will need to bring the actual object to the arbitration itself. Usually photographs, and I know Arlene will touch on that as well, but photos or video evidence will usually be will take the place of the actual object itself to show, well, this is what we needed to show, or for example there, just to jump in while Arlene is...
and Carl, before I'm giving Arlene another minute just to get her voice back, I thought I'd just step in here because, I've been doing this for a number of years. A few years ago, I had to chair a hearing, and the charge was that one person threw a nail at another person, and it was, seen as serious misconduct as assault. And it was only until the nail was brought to me that we understood the case. And it was a nail that was about 5 inches long, and it weighed about 2 kilograms. So it was a steel rod, not a nail. Wow. So sometimes having the object gives context to what really happened. And unfortunately, that was one of the cases where having the object at the CCMA as evidence sitting on the table the whole time really did sway the case in our favor. If we just argued a nail, someone might think it's just a panel pin or something small and innocuous, but in fact it was something that could cause real harm. So having objects there for visual presentation and persuasive value can always be useful. but we don't use it too often. But we should use it more, I think.
I think where it can create or give the specific context and perspective of what you're talking about, it's 100% necessary to introduce that kind of evidence. So no, thank you for that.
Thank you, gentlemen, for saving the day. Yeah, so as I said, so we took the two masks so that the commissioner could see the difference between the two of them. The one was an industrial grade mask and the one was a material mask. And if I didn't have them on the day, and my witnesses explained, but this is the importance of this is how it seals on your face, the commissioner might have been lost, but we won the case based on that we could present to the commissioner, these are the two types of masks, and this was the instruction, and it made it that much clearer. So it is an important type of evidence, but it's not used very often that I've seen, especially in the CCMA. As Carl said, usually photos or whatever would be provided. Okay. And then demonstrative or digital, I think this is also very self-explanatory. Video footage is often used in dishonesty cases or whatever the case may be. I think it's also just important to always be able to prove the authenticity of thereof and to show that it comes from a very reliable source if the question arises for the authenticity of that evidence. Okay. Cole, are we still happy with questions? Will you interrupt me? Okay.
Yes, Arlene, sorry, I'll interrupt you. Apologies. I'm just going through the comment section over here. I'll filter them through to you.
Thank you. Okay. So expert evidence is when we call a person as a witness that is an expert in a specific field. For example, I call a doctor or a mechanic or an accountant. The witness will then be used to testify on specific evidence in his field of expertise. I think sometimes this is also very difficult. In arbitrations, I had a case the other day where a mechanic told me about valves and radiators, and I was completely lost. And I think that's where expert evidence is so important, because if I felt that way, a commissioner might also get lost in the evidence being presented, where an expert witness can then just bring that clarity to break it down in his field of expertise to make clear what is presented to the commissioner. Okay.
Aline, sorry, we have a question over here that I'll quickly just take. Sorry, it came through. Sorry, another question as well. Please remember to follow the rule by delivering expert statements to the CCMA beforehand. Yeah, so that's regarding the expert witnesses. Thank you so much for that comment there. The question that came through was in relation to the POPI Act and evidence. Pretty much when is it going to be applicable and how does it overlap? So just to handle it just quickly, pretty much we handle that on a case-by-case basis. The POPI Act does make certain provisions and exclusions regarding evidence that is used in litigation as well as certain documents. So pretty much you're going to have to handle it on a case-by-case basis, but where necessary, obviously the relevant parties do need to give consent. But it's quite a broad question. If you're maybe more specific, we can take it further. Otherwise, if you do have a proper scenario, you can also reach out to us via our email addresses, which will be provided after the training session. But you can just have a look at the POPI Act, the exclusions there as well. All right. I think we've lost Arlene. Arlene, sorry, do we still have you? I think I'm lagging out.
For the participants that can still hear me, I see we're having some technical difficulties. If you will just be patient with us while we get everyone back online.
My apologies. I don't know if everyone can hear me there. Arlene, there we go. Thank you so much.
I can
Apologies.
hear you.
What is the online training session without a bit of technical difficulties? I'm not sure what happened over the things that we got kicked off the platform, but we are back. Sorry for breaking your flow there, Arlene. You can take us forward.
No worries. I'm not sure if the person that asked your question was answered though, because you were breaking up while you were still answering.
Okay, maybe just to reiterate and pick up from there. So the POPI Act makes certain exclusions where it allows evidence or certain documents to be used for litigation purposes. So these kinds of scenarios, specifically where POPI is involved, we usually take on a case-by-case basis. Where consent is needed to introduce certain evidence, and obviously that would be the correct way to follow. But if there's a specific scenario that you would like to discuss, perhaps privately, please pop us an email. Our email addresses will be made available after the presentation, that we can also assist you further.
Thank you, Cole. Can I proceed? Thanks.
Yes, I see we did get information there. Thanks, Arlene. You can proceed.
Okay, so the next type of evidence that we can look at is an opinion. And I think this is might be, well, this and character evidence, I believe, is quite controversial between parties, and I think will raise a lot of disputes during an arbitration, or points being raised with people not happy about the evidence being led. So when we look at opinion evidence, it can be seen as an impression or a conclusion or a belief that a witness gives during his testimony. And it is inadmissible unless given by an expert or a person who testifies from his or her own observation. So it can be a layperson or an expert who testifies, and whether that evidence will be deemed admissible will depend on whether it's relevant, which is something I discussed earlier, which can then raise a point that the commissioner can decide then whether he will allow such evidence. The ultimate issue doctrine states that only a court and not a witness can impress an opinion about an issue in dispute. So, however, opinion evidence can be admissible if it can assist a commissioner in determining an issue. So I think this will also depend on the merits of your case, depends on your witness, and depends on the commissioner you're in front of on the day. Okay. The same goes with character evidence. It's when someone testifies that a person's actions on a specific occasion were influenced by the typical behavior of that person. So it's basically evidence that is being led to say, well, this person always did this. This is how this person was. They always got aggressive when you gave them critique, or whatever the case may be. So this is the same. The commissioner would have to determine whether it's relevant and what weight it carries in your case that you are presenting. Okay, then the breathalyzer test that has been doing the rounds in the labour sphere for the past few months. So my colleague here in the Bloemfontein office, Kenneth, wrote a very nice article on this. So I would really suggest rather go read that than only listen to my summary, because he really discusses the recent case law of Semanco-Chrome versus Willemse. But it comes down to that a breathalyzer test and the results thereof can be used during an arbitration, but that we should, in most cases, try to support it with other evidence. So that we maybe call a witness to say that when the employee arrived at work, he was off balance and he was slurring his words, or he smelled of alcohol. So that just makes, when you present those results of the breathalyzer test, it's supported by something else. So as I said earlier, so that your evidence corroborates each other. That is the important part of that. But I would definitely recommend going to read the article that Kenneth wrote about it. Sorry, now my voice is leaving me again.
No, not to worry. I'll just jump in there quickly. What we can maybe do, we can just link that article in the comment section as well below for our audience to also have a read there. But it's very interesting when it comes to breathalyzers, because I think a lot of people have the misconception that he has the results, I don't need to lead any evidence. So this is conclusive. And what people don't understand is that you need witnesses, you need verbal evidence to corroborate that evidence that you've brought in. As Arlene had said in the introduction, thank you there for the comment, law of evidence at its best. When you're introducing evidence, it's there to support your argument. Your evidence itself doesn't form the argument. You still have to introduce it, you still have to corroborate it, and obviously you have to deliver your argument based around that evidence. It only serves as proof. So very important. But thanks, Arlene.
Yeah. Okay, if I just want to step in as well on this, sorry, I'll give you a moment just to share some thoughts on this, because I won't get a chance later. I think that a lot of the issues, and it'll come out from the article, stems from the charge and the nature of the way we charge employees for this. And this comes down to something usually in the line of reporting under the influence of alcohol. And a breathalyzer test doesn't determine under the influence, or that someone's abilities to do their work is impaired by a breathalyzer test. So it's something that needs something more than that. If you're going to say that a person was under the influence of alcohol, you have to show some form of an observation test, which would then support the breathalyzer test. And I think those are some of the problems which have come out in the recent case law and the way that the law is moving in that area. So you certainly do need to make sure you tick all the boxes in terms of observations, the breathalyzer test, because breathalyzer tests as well are also accurate, but not. There are exceptions to that in terms of calibrations and testing the machinery. So there's a lot of issues involved there, and people rely very heavily. A lot of employers rely very heavily on breathalyzer tests alone. I think that has been problematic in the past, and hopefully that'll change in the future with more better evidence gathering techniques by the practitioners.
I think before I just address the question that's come through here, I think as well from a bit of my criminal law background, it also depends, and it carries through to civil and specifically to breathalyzers. It also depends on the nature of work and how the alcohol has affected or impaired their ability to perform that work. So, I mean, there's a different standard applied to someone who's operating heavy machinery in a mine versus someone who's maybe just a bit slurred behind a desk. So also you have to look at I think it's something that, in the legal profession, we say a lot, it depends on the merits of the case, but it really does, because each specific circumstance is handled on its own accord and depending on what the evidence is and the merits there. Just a quick question, what about blood samples? Stephen, sorry, I don't know if you want to take it or if you'd like me to.
I have to unmute myself. So blood samples are problematic in a different sense. Although they're accurate, there needs to be certain consent given, and one cannot, as an employer, you cannot force an employee to give up a blood sample. So it is accurate testing, but it is something that is not, you cannot make it compulsory. There is constitutional issues there. I have had a number of cases where an employee was charged with misconduct in the form of reporting under the influence, and they voluntarily went to Pathcare, got their own blood samples immediately after the incident, and it came back and showed that there was, in fact, very low levels, if anything, levels of alcohol in the bloodstream. And that could, in an arbitration, that would disprove the employer's evidence, because it is quite reliable. So it's something that swings both ways in terms of the employee getting it out of their own accord to enhance their defense, but also as an employer to force the employee to get a blood sample, even if it's a contractual arrangement, is problematic in terms of the Constitution.
Yeah, I think just to bring it full circle, so with blood samples specifically, besides the constitutional issue, even where there is consent given, the same would apply to breathalyzers. It only forms part of the evidence as far as it's corroborated. You still have to bring an expert or the person who maybe took the blood sample, so you're complicating it for yourself, because you as an employer would not be able to testify to that blood sample because you're not the person who took it. You don't have that medical background. Even if you understand what the document says, you would have to bring in the relevant witness to come corroborate it, to support your argument. Say, listen, there is a zero tolerance policy at work for alcohol. this person was over, and this is the effect and how it impaired his ability to work or her ability to work. But anyway, sorry, we digress a bit now. I hope that answers your question. Arlene, back to you.
Yeah, so that's why I said this is quite a controversial topic, and I think if you ask different institutions and different lawyers, they might give you a different answer on what they deem fit in this. I have done a case recently in this, and unfortunately in that case we didn't have an observation test, but we had other things that could corroborate that the breathalyzer test was enough. We had proof that it was it's a automatic system that they use, and that it was what do you call it? Now I can only think of the Afrikaans word. It was serviced. That's the word that I'm looking for. It was serviced recently, and that he only did not, because at each gate there was a breathalyzer, and he went to 4 different gates, and all 4 gates had a positive result. So evidence like that made our case stronger, but I would have been more comfortable in a case where I had a witness that was there at the gate to say, but he was slinging around or slurring his words or whatever the case may be. So that is important in presenting evidence of a breathalyzer test.
Okay. Sorry, Arlene, before you move on, I just want to tell the audience that the article has been linked in the comment section. Can an employee be dismissed for the results of a breathalyzer? I do suggest that if you have an interest in that and maybe you were curious, please have a read there. Thank you.
Thank you, Cole. Okay. So, before I don't leave any time for Stephen to touch on his things, let me move on. Okay, so the next thing is, I think, very controversial as well, is polygraph testing and when that can and cannot be used. So it often happens, and a lot of our members use polygraph tests when they suspect there is serious misconduct in the workplace. And even though polygraph tests cannot and should not be used as the only evidence to prove on a balance of probabilities that someone is guilty, it can also be used as a breathalyzer test, as a supporting or aggravating evidence before the CCMA that someone has allegedly committed misconduct. So if it can be corroborated with other evidence, it's also something that can be used during an arbitration. Okay. The next one is circumstantial, and this in itself is basically a semester subject. And I can discuss this for quite some time, but there's also a great article on this one as well. I'm not sure if that should also be linked. Sorry, Cole, for doing this to you. But there is my colleague in Durban, Shakti, also wrote a very nice article on circumstantial evidence. So circumstantial evidence is the use of the facts that you already have put before the commissioner. Or let me read my sentence to you nicely, because it's going to make sense better that way. The courts and labour dispute firms in South Africa have permitted the use of circumstantial evidence to prove that an act or omission or offence took place. In contrast to direct evidence, circumstantial evidence relies on drawing inferences from proven facts. So I'm going to use the example that Shakti used in his article. So Tom and Tim are employees at a cafe, and they are the only 2 that have access to a staff room. This staff room is secured under lock and key, and on a specific day, on a specific day, Tom stores his laptop in this room, and he goes on lunch. So when he returns to work, he discovers that although the staff room is locked, his laptop is missing. So he notices there's no damage to the door, there's no windows broken, but his laptop is missing. So Tom then views the CCTV footage and observes that Tim enters the staff room during his lunch and exits it by locking the door again, but he's also walking away holding something under his jacket. Okay, so although there's no direct evidence that shows Tim taking the laptop, the only reasonable inference from the fact is that Tim took the laptop. So that is an example of what circumstantial evidence is. It's without having to say to a commissioner, there you can see Tim taking the laptop, the inference is very clear that he's the only person that had access. But now this also places a burden on you to prove, is there anyone else with a key? Because you can't just make this assumption. So you're going to have to prove to the commissioner no one else had a key. You're also going to have to prove, did Tim actually put his laptop in there? Because if he lost his laptop somewhere else, and Tom says there was never a laptop in there, then that's also a different type of story again. Okay, so even though circumstantial evidence is admissible at the CCMA, there are standards of what needs to be proved before a commissioner. So I can't just make the inference myself. I have to draw a picture for the commissioner that no other inference can be made, but that the misconduct took place. Okay. I don't know, Stephen, you're nodding. I don't know if you want to add to that.
I have to be honest. I enjoy, and I don't know if I'm being sadistic about this, but I enjoy preparing for cases where we only have circumstantial evidence. You approach it in a different way. You know, you need to think very hard about the evidence that you want to present. And the way that I normally attack something like this is thinking about it as a puzzle. And the thing about a puzzle, you don't need to complete the puzzle, all the pieces, to see what the end picture is going to look like. You just need more pieces. And as you put more pieces of the puzzle down and you put another inference that is drawn, it's like adding another piece to the puzzle. And maybe a 30 or 40 piece kid's puzzle, you only need about 14 or 15 pieces to know what the end picture is going to look like. You can draw in the rest. So that is how I often think about circumstantial evidence, is really about excluding the alternatives, that the only inference you could draw is the fact that we are looking for, is the premise that we're looking for. So I quite enjoy that. I think the courts once said, it was a fantastic quote, said that circumstantial is very much like the aroma that comes out of a recipe. So if you can imagine yourself cooking and you're making this pot of stew, the circumstantial evidence is the smell that comes off. Now, you don't know what the ingredients are, but you can sometimes get the aroma of all these things put together. And if you start thinking about circumstantial evidence in those ways, your approach will be more holistic in terms of thinking about everything around you, excluding alternatives, and you'll find that you can be quite successful only having circumstantial evidence. Although it's not the primary route that you should disregard direct evidence, but having circumstantial evidence can be beneficial if you think about it strategically, and I'll deal with that a little bit later in the presentation. Thanks, Carl. Thanks, Carl.
Thank you, Stephen. I'm loving the analogies. I just want to quickly just say, listen, we are on a timeline, unfortunately, so we need to keep it a little more brief, just so that the audience can obviously watch the in one go. Thanks.
Okay, the last thing that I want to say on circumstantial evidence, I think, and as Stephen said, you can really present a case on this, but you also need to be really, really well prepared. You need to know the puzzle pieces before the applicant does, because if they have a piece that you are missing, then you're going to be in trouble. Okay, the last type of evidence that I'm going to discuss, and then I'm going to pass over to Stephen, is hearsay evidence. So this relies on what you heard from someone else. This is not your own opinion or your own version. This is you presenting someone else's version. And generally, it's not allowed in legal proceedings because the original source isn't there that you can place them under cross-examination. However, there have been cases, and some commissioners will allow certain things. As I said earlier, it depends on the relevance to your case, but in most cases, it would not be admissible. But I think Stephen will maybe address that as well. But that's how far I've got. Thank you for everyone joining. That's the types of evidence, and then we'll give it over to Stephen.
Thank you so much, Arlene. Very informative. Apologies for rushing you along now. It's just we do try to keep to our timeline. And as I said, there's so much we can talk about. But yeah, without further ado, I'd like to hand over to our Provincial Manager of the Western Cape, Mr. Stephen Kirsten. Stephen, thank you so much for being here. I know you've had a few comments already, but please take us through the admissibility, weight, and effectiveness of evidence.
Thanks, Carl. I appreciate you allowing me to be here. So what I'm really want to be talking about when we're discussing admissibility, weight, and effectiveness is a little bit about strategy, how to approach the evidence that you have, to think about it, and to try and avoid your shortcomings that you might find at a later stage. So, you know, when we think about these three concepts: admissibility, weight, and effectiveness. It's the AWs and the E's, the O's, and it can go from awful to awesome if you apply your mind. It's not thinking about it and not understanding these concepts can be problematic. So let's just delve into the first one: admissibility of evidence. I think that Arlene did touch on this. The reality is that regardless of whether it's a criminal case, a civil case, a labor case, the rules of evidence apply. And like a game, whether it be rugby, soccer, any game, there are certain rules that you need to abide by. And admissibility of evidence is something that can trip up some people. So in order for it to be admissible, there are a number of concepts, but ultimately it must be, the simplest way to describe it, must be lawfully obtained, and it must be fair to be able to admit that evidence. If evidence is unlawfully obtained, then it would be inadmissible. Now, in our law, strange enough, the issue of admissibility of evidence raises most in criminal cases, and it often circles around the issue of admissions. So it's very frequent that in criminal cases, litigants and parties will argue the admissibility of admissions that were made, simply because those admissions can be detrimental to a person's case, and having it excluded is a great advantage to the party who can successfully have their own admissions excluded as evidence. Now, if evidence is excluded, made inadmissible or disqualified, the commissioner or the judge will not consider that evidence at all. So that could be quite detrimental for you as the person who is presenting the evidence, or the one who is orchestrating the presentation of evidence, that you might be relying on evidence which ultimately is deemed to be inadmissible. In terms of, so fortunately, I must say in my experience, it very rarely comes up that the question of admissibility is an issue. But the one area where it does come up quite often, and I'm going to deal with that later in this presentation in a few moments, is hearsay evidence. It is something that is raised either by the other party, if they are represented, or by the commissioner himself, who says, well, look, this is hearsay evidence, and we need to deal with whether I'm going to consider it or not. Now, in the law of evidence and our rules, the admissibility of evidence is dealt with in a process that we call a trial within a trial. So we don't deal with the actual case itself, but we deal with the issues of the admissibility of the evidence. And when we go into the example of dealing with hearsay evidence, you'll understand the considerations that the commissioner will make regarding hearsay evidence and its admissibility. And you will understand the picture that he's not considering the case itself. He's not considering guilt or finding or whether the dismissal was appropriate. He is only determining whether he should consider this evidence or not. So if evidence is deemed to be inadmissible, it cannot be used, and it will be struck off. So one needs to be just really clear or understand that you don't want to be relying too heavily on evidence which it can be deemed to be inadmissible. In terms of witness statements, you're not really going to have a problem about admissibility. You might have an issue of weight, but in terms of admissibility, as long as it's relevant, witness statements are not a problem. But when a person is dealing with information which is not information that he saw something or he experienced it firsthand, but rather something that he heard from somebody else, that becomes hearsay evidence. And you need to ensure that you don't have those type of circumstances. So hearsay evidence is essentially evidence that was not witnessed by the person who is testifying, but by somebody else who explained it to him. Now, hearsay evidence is admissible in certain circumstances. The criminal courts are a little bit stricter on it. In civil courts, civil proceedings, and in labor proceedings, it is admissible considering certain circumstances. And I think we can go to page 13. Call the next slide. I want to deal with hearsay evidence. Just move on.
Sorry, while we wait there quickly,
There we
just
go.
sorry, Stephen, just to jump in quickly. I'm sorry to, before we delve into here, so I just want to deal with two comments that came through. The first one was that the linked articles have now been shared to Facebook as well. So apologies for that. They should be available on all the platforms that we're streaming to. And then the second thing is a question, I think this goes back to what Arlene was discussing, is how do commissioners approach witness testimony when the witness is another employee of the employer? How would their testimony be validated as not being given under bias towards the employer? So, Stephen, I don't know if you want to jump in there just to answer this briefly, but just my 2 cents is that obviously there's a presumption of not being biased, and that the person alleging bias would obviously on a balance of probabilities have to show why that witness is being biased towards the employer. But you can take it further, seeing as you are delving into hearsay and witness testimony.
Yeah,
Thanks,
absolutely. I think look, it's an interesting question, but I think it's something that you've dealt with it correctly. I think it's a presumption that is not made readily by commissioners, that one person testifying against another person is doing it for a motive other than to tell the truth. But the reality is credibility of witnesses is determined holistically, not only on external circumstances, but really on what that witness is saying and how that corroborates, and we'll deal with that with other witnesses who've tested on the same issue. So I think that I would not be overly concerned that commissioners do disqualify a witness as being biased. It's unless it's raised by the other party, and if they raise it or allege it, then they must prove that the person is biased. But it's something that is very rarely happens at these proceedings. So moving on to hearsay evidence. So the thing about hearsay evidence is you need to be very cautious in terms of witness statements, that the person who is testifying is something that they saw, not something that somebody else has testified to or told them in a story, secondhand evidence. But it also relates to documentary evidence, that you cannot have somebody commenting on a document of which they weren't the author or involved, because that would be hearsay evidence as well. So you need to be alive to the fact that documentary evidence can also be considered hearsay evidence. But it doesn't mean that all documents are automatically hearsay and that the person who's not the author cannot testify to those documents. So if one is dealing with a disciplinary code within a workplace, for example, you can a manager who works within the company can speak about the disciplinary code. You don't need to get the author of the disciplinary code. It's really only when the content of the document is being disputed and the person who wrote that document would be the only person who can testify regarding the content and the context. Now, the issue with hearsay evidence is that it is unfair to lead hearsay evidence and the other party cannot cross-examine or test the evidence. And that is the problem with hearsay evidence. It's a matter of fairness. So it's not an issue of legality and the obtaining of it being legal, but it's an issue of whether it's fair to present it or not. The courts have said that there are 4 circumstances. I'm going to run through these very quickly because there's quite a lot we need to go through. There are 4 circumstances under which admissibility of hearsay evidence will be permitted. Firstly is that each party agrees that it can be admitted. The person whose credibility the probative evidence on the side of the value of such evidence depends themselves testify at such proceedings. And put more simply, the witness who witnessed the incident will testify later in the proceeding. I think that's what that sentence really says. The third one is it would be in the interest of justice. And then the 4th circumstance is that the hearsay evidence is supported by independent evidence. So you can have independent evidence which would support the hearsay evidence, and those are the circumstances under which hearsay evidence will be permitted. We can move on to slide 14. And here is what I said earlier, you have a trial within a trial. And this was really I think this was decided in Swiss South Africa versus Lowe about 20 years ago. The court will have regard to certain issues when they consider whether the hearsay evidence will be admitted. And that is the nature of the proceedings, the nature of the evidence, the purpose, the probative value of the evidence, the reasons why the evidence is not given by the person whose credibility, the probative value. The person who wrote the document, the person who saw the incident, why are they not testifying? Can they? Are they available? Whatever the case might be. Those are the questions that the commissioner will ask whether he's going to consider the admission of the hearsay evidence. So thinking about admissibility, you really need to be alive more than anything to hearsay evidence. And you can avoid the issue of hearsay evidence with properly prepared witnesses who are testifying to events that they saw, not events that they heard from somebody else that somebody else saw. You need to be aware of that the information and the evidence is not secondhand evidence. Now, moving on to the next issue, even if the hearsay evidence is admitted and the commissioner says, I will consider this evidence, it carries very little weight. And we're moving on to the weight of evidence. So that will be the next slide. So weight of evidence is the persuasiveness or the believability of that evidence. I think the trick here, and in terms of strategy, and when you're preparing yourselves for those practitioners who are going to be presenting evidence or introducing evidence, you need to be as objective as possible. It's no point in just calling witnesses who support your case, but objectively speaking, what they're saying is not believable. And I think you need to address that and consider that when you are considering the evidence that you're going to present. Now, weight of evidence is the best evidence that carries a high weight is usually a credible eyewitness. So someone who saw the incident, they are credible, they can account to the material facts, they're coherent. Those are people who are believable. That the commissioner will say, I believe what they're saying because it makes sense to me. I trust them. That evidence will carry high weight. Somebody who testifies about an issue and he is unclear about if the material facts, he wasn't sure what happened, that witness evidence carries little weight, little persuasive value. Now, you cannot correct low weight evidence by bringing more of it. So I'm going to say something now which doesn't make, I read it out and I read it and it just doesn't make great, it's not English, but it's a lot of a little weight does not equal more weight. So if that makes some kind of sense. So don't think that I'm going to call many witnesses who are vague and that will be more weight I'm adding to the scales that Arlene spoke about earlier about the best evidence. This is the worst evidence, and a lot of the worst does not make the best. So you need to think about selecting the evidence will carry the most weight, whether it be good witnesses who can be coherent and who are believable. That is the importance, considering those, and people who add little value to your case in terms of the material facts should be excluded because they're not going to add more, than they have little weight and it has little value. So as I said, so things like breathalyzer tests, polygraph tests, hearsay evidence, irrelevant witness testimony, those all carry little weight. Some weight, but little weight. So that's why it's important to have other evidence which supports that with more weight. So a good witness testifying about, an expert testifying about a breathalyzer or a polygraph test suddenly adds a lot of value to those things which have little weight. Now, does this matter to your case? Absolutely. You might subjectively think that you have the best case because these people are going to support what you are presenting. Problem is that objectively viewed, they're not believable and you are fooling yourself. So you really need to step back, think about what they're saying. If a person says, I saw this from this time and this is what I saw, go and stand where they were standing and they say what they saw and see if you can see the same thing. So test the evidence so that you can be persuaded yourself as to the believability of those witnesses. Now, we can go on to the next slide. So just bear in mind what I said, low weight, a lot of it doesn't equal more weight. You've got to use the best evidence that you have, and less of the best is better than more of the worst. Effectiveness, and this comes down to think of yourself as the conductor of an orchestra. You're the only person who can see all the pieces of the orchestra that are moving. How are you going to be able to be effective in what you are leading? Now, there's three elements here. The one is relevance, the one is efficient, and the other one is coherent. And this comes down to preparation of your witnesses. You need to prepare your witnesses that when you ask a question about what did you observe on the 15th of January, then the guy says, well, I woke up in the morning and it was sunny and I went and had breakfast. It's irrelevant. You've lost the plot. You need to your witnesses to be able to speak about what they saw, and well-prepared witnesses will be able to do that. So effectiveness is about having effective witnesses saying the right things and only dealing with the relevant issues. Now, when you prepare your witnesses, I want to just caution you not to coach witnesses. There's no point in having 3 witnesses in the same room at the same time being coached to say the same thing and thinking of that as a corroborative issue. It's not. Each witness should independently be able to account what they saw and be able to repeat that. You need to be satisfied that they could do it independently and that those 3 versions match. So you need to think of what they're saying is relevant, keep it efficient, that they're only dealing with the important material facts, but also that they're coherent and not speak about nonsense and how they felt and issues. So we deal with chronology. Does it make sense if you're looking at time at your timelines and viewed objectively? So you need to think of those 3 things, the A, the W, and the E, in order to be able to do as little as possible, as effectively as possible. Less evidence is better than a lot of evidence, which is not good. Sorry, Carl, we are tight on time. Can we just move on to the last issue?
No, we are briskly running through it, so you can continue. I just want to make one comment quick. I'm not sure if I saw it on a movie or if it was something I read, but it's with coaching your witnesses specifically. I am not a fan at all. Coming from a criminal law background, not my vibe. But they say that when you tell a lie, you have to remember it every single time you tell it to make sure that it's consistent. But with the truth, you experienced it and you just retell it in your own words. So that's something that I would tell witnesses as well. Just tell the truth as you remember it. Obviously, you want to make sure that they remember it the way they told you the first time, but it's the easiest way to obviously testify, is just to tell your truth.
Thanks for that, Carl. In fact, and I know that we are tight on time, and I hope that people are still engaged in what we're saying. So we could talk on this for hours, but what I wanted to do, and before we run out of time, I think it's something that's very important. When I was dealing with admissibility, I just touched on the issue of admissions and how those are so relevant in criminal cases. I think you need, as practitioners, you need to be alive to the question of admissions that have been made. There's nothing that can further your case more than using previous admissions that were made by the other party. Those are often made at the disciplinary hearing. So having a minute of the disciplinary hearing and using the version that was presented then to further your case. As Carl just pointed out now, if somebody is lying or they're giving you a mutually destructive version to your version and somebody's not telling the truth, there are inconsistencies in the thread. And very often you will be able to eke those out by putting the version of what was presented at the hearing, which is often very different to a version that is presented at arbitration. So admissions and submissions, I'll put those together, are very important in terms of the presentation of your case, understanding the other party's defense, but also holding them to a version that they presented beforehand. That can also be used if you have a default arbitration award. So very often employee will go get a default award because you didn't attend, it's been rescinded, and now you're arbitrating. You can use that version that he presented in that default award against him if it materially changes to something completely different. So admissions are very important. Try and be alive to those in terms of presentation of your case and being efficient. Introduction of evidence. So evidence doesn't speak for itself. Evidence, we can move on to the next slide so we can move through it. So a bundle of documents cannot be handed to the commissioner and you can ask him to just wander through at his own leisure. Evidence must be presented and introduced. So if you're referring to a document, a contract of employment that you're referring to, you need the witness to introduce the document. So you don't go to page clause 17 of the employment contract. First, ask him to introduce the document. What is the document? Whose document is it? When was it signed? So that the commissioner knows the document. And if the other party wishes to object to the authenticity of that document, they could do so then. But you need to do that before you just delve into a clause within a contract. So in terms of introducing evidence, the evidence is not the same as an argument. And I think I would encourage all of you to use the opening address as an opportunity to explain to the commissioner how you're going to prove the facts. So deal with the commissioner with what you want to prove, what you're setting out to prove, the which witnesses you're going to call, who they are, and essentially what they're going to testify to, as well as the bundle of documents presented to him, and make sure that before you address any of the documents that they are introduced into evidence. Now, yeah, so I just wanted to see if there's anything else I wanted to issue here. The last issue on this page is, why do you only need to lead evidence on what is in dispute? The narrowing down of the issues in dispute are almost always to the advantage of the employer. Very often, most of the cases that we deal with, and Arlene mentioned this earlier, is dismissal disputes, where the employer has to prove all the elements of the case. So they'll have to prove that there's substantive fairness, there was a rules broken, there's no inconsistency, it's a reasonable rule, and that dismissal is an appropriate sanction. If you can narrow down the issues, so for instance, the applicant or the employee admits that he committed the misconduct and that it was a reasonable rule and that it has been consistently applied, and the only thing disputed is the appropriateness of the sanction, you don't need to lead evidence on all the other issues. You only need to lead evidence on whether the sanction was appropriate or not. So things that are not in dispute, you don't need to lead evidence on those issues. So we narrow down the issues, find out what we can get away from having to testify about and lead evidence on, because that will make your life easier. We also deal with issues of common cause. Before the start of the arbitration, make sure that you have as much common cause as possible, where parties are in agreement as to certain facts. Start, commencement date of employment, salary at time of dismissal, the dismissal date, the reasons for dismissal. If those things are agreed beforehand, then you don't need to lead extra evidence on those. Now, the last issue that I want to deal with is corroborating evidence. I use a term, an analogy with my members, that 2 is 1 and 1 is none. 2 people saying the same thing will always trump 1 person not saying something different. Now, the caveat to that, if those 2 people are speaking nonsense, they will not, or clearly lying, they will not trump the 1 person. So credibility is the caveat to that. But 2 is 1 and 1 is none, which is why it's always important that you have corroborating witnesses, if possible, 2 people saying the same thing. Now, that doesn't mean that you must call all the witnesses who saw the same event saying exactly the same thing. It's unnecessary. Corroborating witnesses usually have your best witnesses, whether it be 2 or 3, as few as possible, to corroborate each other. And then that is usually, you're layering the evidence on top of each other, and it will almost always trump the single person who is saying something different. But just remember, corroborating evidence is not corroborating if they don't say the same thing, if they're inconsistent, because then you have an issue.
Sorry, that what you said about corroborating the witness version, I think that just goes to one of the comments we received. The more witnesses, the more versions. And that's so true. The more versions before the commissioner, the more you can pick apart, the more you can cross-examine, and the higher probability of inconsistencies appearing. Even if 2 people are more or less telling the same story, they will be different in certain aspects. And the minute you can pick something out, you can cross-examine it.
Yeah, and it's important to understand that 2 people will not say exactly the same thing, because their perspectives will be different. The way they experience the incident will be different. So you don't want them to be repeating each other like a computer. They want to say slightly different things, but as long as the material aspects are really the same, that is effective corroboration. But corroborating is not only about 2 witnesses testifying about the same thing. It can also be about a documentary evidence. It can be about a video footage that is corroborated by eyewitnesses. All the different various types of evidence that Arlene addressed can corroborate each other, support each other. And that is something you must always look for, a common thread in the different types of evidence, because that is effective evidence leading. And that would really support your case. So I think I'll try and be alive to that and look out for corroborating evidence. Thanks, Carl. That's I know we've rushed through it because we're so short on time, but if there are any questions, anyone is more than happy to.
Yeah. Thank you so much, Stephen, for taking us through that. And Arlene, thank you both for being here. I think your presentations are very informative and knowledgeable. I see we have more or less answered all the questions that I can see in the comments. If I have, for some odd reason, missed one, please feel free to contact us, or I'll go check the comments on our platforms after. But thank you so much for presenting today, guys. I really do appreciate it. I hope the audience enjoyed themselves. I hope you guys leave here knowing what's expected of you and a little more knowledgeable, and maybe a shift in perspective from an evidence point of view. Just from my side, CEO is always conducting further training and ongoing development. Please keep an eye out for our next training series, which will be advertised in due course on all our various platforms. Just to reiterate, the recording and the slides will be made available in the recording themselves on our platform. And if you have a specific need for training, we do reach out to our members and prospective members as well to try accommodate and develop training for you guys specifically. So if you have any specific needs, please pop me an email and we can discuss. My details, together with Stephen and Arlene's, are available on the screen over there. Please take a photo. If you miss it, you can just go have a look at the recording again. And then please give us a like and a share on all our platforms. We are on Facebook, Instagram, LinkedIn, and Twitter. And I know we also have a YouTube channel, which we have streamed through today as well. For any other queries, you can visit our website. I sound like one of those infomercials saying all these different things. But yeah, thank you guys so much for attending. We really appreciate your time and for being here with us.
Thank you very much, Cole.
Thanks, Cole.
Thanks, guys. All right. See you at our next session.